On the screen here, you will see what some see as an aquarium or a fish tank with an arbitrary number of $2 million at the top left-hand corner of the screen. Inside of this fish tank, you see many different types of coral, fish, turtles, all kinds of things. What that represents are your assets. So your assets are inside of the fish tank and the assets are $2 million. We in life come across some, primary
issues, I would call it.
or holes in our plan. So each of the holes below are in our fish tank, and our goal is to stop the assets from leaking out of your fish tank. Today, we're going to cover the topic of probate. So probate is simply the legal process that the probate court takes to identify all of your assets, pay off all of your debt, and then distribute your assets. Otherwise, establishing clear title to all of your assets, paying off those assets, and then distributing them according to your will. We have some common issues with probate. The first issue is the average cost, which, as you can see on the screen, is 5 to 10% of your gross estate. So in our example, we have $2 million. And if your estate needed to go to probate, it's going to cost your estate 5 to 10%. Simple math is 5% on $1 million. That's 50,000. Multiply that by 2 because the estate is 2 million. That's $100,000 on the low end. The high end is 10%. Okay, so it could be $200,000 on a $2 million estate. You can call me cheap if you'd like to, but anything I have to pay to hand over assets to my family is a penny, a dollar too much. Moving along, the second issue with probate is the time that it takes to complete the probate process. 6 months to 2 years or longer is the typical time frame that it takes a estate to go through probate, depending on the assets inside of the estate. Simple estate, you're probably looking more on the 6-month end. Something with businesses or real estate involved, you're probably looking at least a year to 18 months. During this time, you're still paying to keep the house going, the business going, paying HOA fees, insurance, maintenance, the list goes on. But as you can see, it is slowly, charging your estate or draining your estate of those fees. This is a public process. The process takes place at the probate court in whatever county you reside in, and everything you've been working on your entire life to keep private is now public. That can mean social security numbers. It can mean your wealth. I use the example of James Gandolfini from The Sopranos. If you Google him, you can research that his estate at one point was public information. Very wealthy individual, didn't have an estate plan, so it was all out in the public. Don't let that be you. And fourth is a stressful process. Who is it stressful on? Well, not you, because you're no longer around, but it is stressful on your kids or your beneficiaries, as they probably do not have the experience in settling an estate. They may also be out of town, out of the country, have to hire an attorney, fly into town. So it causes numerous amounts of, issues to your beneficiaries or your children. So how do we solve that? Well, on the screen, it's simple. Establish a revocable living trust. Keyword is revocable, meaning that it can be changed and that you own all of your assets. You are not handing over ownership of any of your assets in a revocable living trust. We're going to list a few ways here or reasons to establish a revocable living trust. It's inexpensive, immediate. It's a private document that is not filed with the court, and no stress, or at least a lot less stress on your family. Let's go back up to the top. Inexpensive. Relative to the 5 to 10% cost that it would, charge your estate in probate, you can get an estate plan, a revocable living trust with all the documents that we're going to discuss here in a minute for somewhere around $2,000. Okay, so compare that to, let's call it the $200,000 that you could be possibly charged to your estate if you had a $2 million estate. I think I'd rather go with the $2,000 option. It's immediate. As soon as the documents are notarized, the document is now a legal document. You are simply creating a legal entity to hold your assets with named beneficiaries to them. So upon your passing, it does not go directly to the beneficiary, but it's going to go to the trust will hold the assets, and they are now creditor protected to your beneficiaries. It's private. Nosy neighbor, family member, you don't want to know what's going on. Well, this is a private document. No one sees it. for any reason besides those that you share it with, and no stress or less stress as indicated by the happy family on the screen here. There are some common concerns about establishing a revocable living trust. One of them is, do I lose control of my assets? No, you do not lose control of your assets, as the keyword is revocable living trust. So you are able to maintain ownership of all of your assets, change ownership of your assets, and also buy new assets. Another common concern is, what if you own property in more than one state? Not a problem. We commonly handle more than one property outside of the state of Florida for us, because we're based here in Wesley Chapel. So other properties, we're able to, research the deeds and also retitle that property. Another common concern is, how do I put assets inside of my trust? So come across many people with trust or trust documents, and I ask them the simple question of, have they funded their trust? They say, what do you mean fund my trust? Well, you can pretty much take that trust document and throw it in the garbage, as it's just a paperweight if it's not funded. Funding your trust means placing your assets inside of the trust. That can mean your brokerage accounts, bank accounts, properties, and so on. All right. So we talked about putting assets into the trust, an extremely important element of establishing a trust. You do not put your assets in the trust, it will still go to probate. Can I use payable on death, or POD is what you would see on bank accounts? Okay. You can use POD. It will go to your beneficiaries immediately. And the key word is immediately upon the passing. So basically, someone, passes along, that account will go to the, beneficiary listed through payable on death. The issue with that is, what if that person is going through a lawsuit, whether it's a divorce, car accident, whatever the case may be, any legal matter, and they inherit a large sum of money, or a large amount of assets, that money is no longer creditor protected. Whereas if it was in a trust, that money would be creditor protected, and a husband couldn't come after the money, or a wife couldn't come after them, which is very important to some folks, that they want to make sure that their money gets to the intended recipients or grandchildren. For example, it's important that you understand the difference between payable on death and the assets being transferred to your trust. As a firm, at Accurate Advisory Group, our team has established over 6,000 trusts for our clients. What comes in the trust package is a revocable living trust. That is the legal entity you are creating to hold all of your assets. Durable power of attorney, healthcare surrogate, living will, and pour over will. All right. These are all extremely important documents. The durable power of attorney, everyone should have in place, that allows for, financial decisions to be made. Healthcare surrogates is in regarding durable power of attorney for healthcare. Living wills as your end of life care. And then wills and pour over wills, which directs the assets to those specific beneficiaries. In addition, at our firm, we'll also correctly title your real estate. We didn't talk about it yet, but your primary real estate, as well as any vacation homes or secondary homes, should either have an enhanced life estate deed that lists beneficiaries upon your passing to avoid probate, or the trust itself should go ahead and receive those assets, then distribute them through the trust. If it's not going through the trust, or if it does not have an enhanced life estate deed, the property will go through probate, and that is a timely and expensive process. We also offer free calls to our attorney once you establish a trust with us, and then we also provide assistance in estate settlement. So that was a quick tutorial or educational session on why you should have an estate plan, and we'll see you next time.